Hello and welcome to Unworthy History. We try to talk about actual history that's now unworthy of TV channels like the History Channel. So today I'm going to bring you some more Texas history, but this is actually about one of the first settlers of Texas back around a little before 1820, William Smothers. This is a story that happened to him a few years before, about 10, 12 years before he finally ended up in Texas. And it's one of the first stand your ground case laws. It was actually argued by Joseph Hamilton Daveiss, who have done a whole series on. But this is a story of Smothers, and he found himself caught up when he was living in Kentucky. He actually lived near present-day Owensboro. It was called Yellowbanks back then, and he lived like right on the river. And so this is a story about an incident he had where he really had to stand his ground, and one of the first stand your ground defenses that we'd see in the U.S. So this was all occurring around the year 1807 or 1808. One sultry evening, as the last rays of the setting sun were playing upon a bank of cloud fringing its outline in purple and gold, Smothers and his sister sat upon the doorsteps enjoying the cool air and silently enjoying the splendors of the scene. Unnoticed by them, a keelboat had made fast at the landing, and several of the men were already in the yard. The foremost, a man by the name of Norris, was of Herculean proportions, and it was the boast of the crew that he had never met a match in a fisticuff from Louisville to New Orleans. Miss Molly left the side of her brother and entered the house. When they approached, Smothers arose from his seat and invited them to walk in. They indulged themselves in such freedom of remark that Miss Molly concluded she could not remain with propriety, and ran to the house of Felty Husk. Smothers, who had not observed the absence of his sister, remonstrated with them in mild but very decided terms upon their unbecoming and unworthy behavior. The firmness of his manner and the truth of what he said made an impression upon the boatmen. 6 of the number, upon leaving the house, called to Norris to come and go to the boat. He told them to go on and that he would be along directly, but he never went. In the dim twilight, Smothers saw 10 or 12 of the crew ascending the bank in line to his house. Retreating by the back door, he concealed himself in a bed of strawberries which grew in his garden. When they entered and beheld the lifeless body of their comrade Norris and friend extended upon the floor, with the warm blood still trickling from 2 ghastly wounds, their rage and indignation knew no bounds. They threatened to hunt for Smothers until they found him, and to slay him at the sight. Perceiving that they were searching and ransacking the house and expecting them in the garden, he left his hiding place and spent the night in the woods. At daylight the next morning, he knocked at the door of Ben Duncan, Esquire, who lived on Pup Creek, 10 miles above Yellowbanks. He informed Squire Duncan of the nature of the charges which had been made against him on the night previous, and demanded a judicial investigation. Squire Duncan summoned the boatmen as witnesses and opened his court of inquiry. In answer to the summons, the crew came in a body to the house of the justice. Many of them were armed and declared it to be their intention to seize the prisoner and hang him to a tree. But the friends of Smothers were there, and no man had more friends or truer friends than he had. They told the boatmen if they opened the ball in blood, that the sun of that day would shine on many a corpse, that Smothers had surrendered himself to the officers of the law and was a prisoner, that they could give their evidence if they had any, but if a hand was raised in violence, they would resist it to the death. As they were prepared to make their words good, the examination went on smoothly and quietly. The court decided that the offense was valuable, and required Smothers to give bond and security for his appearance on the first day of the next term of the Ohio Circuit Court, now the Davis County Circuit Court. The bond was immediately filled by the prisoner and a number of securities, and after recognizing the witnesses, the court adjourned. Smothers, with 6 of his chosen friends, returned to his home. The boat was still at the landing, but the war was not renewed. So I think what's happened up until this point is Smothers. I think what the story doesn't tell us is that this Norris fellow may have done more than just said things to offend Smothers' sister. He may have actually sexually assaulted Smothers' sister, and so Smothers shot him, and he's going to claim self-defense. Smothers was much perplexed in mind upon the subject of employing good counsel to argue his case before the circuit court. For all minor offenses he had appeared on his own behalf and had been uniformly successful, but in a case which involved the question of his life or death, he was unwilling to trust himself. But he was poor, and lawyers' fees were high, and he knew not well what to do. His anxieties about the matter were happily relieved. The great advocate, Joseph Hamilton Daveiss, knew Smothers well, and admired him greatly for that indomitable courage which never had been known to quail in the presence of danger. He heard, at Frankfort, of the affair, and sent Smothers a message which was characteristic of the man. "Don't ruin yourself hiring lawyers. I will be with you on the day of the trial." Smothers knew his man, and relied upon the promise with implicit confidence. The fame of Joseph Hamilton Daveiss as an orator and the widespread acquaintance of the accused brought a concourse to court, such as had never been in Hartford before. The keel boatmen from Louisville were there, and strangers from a circuit of 100 miles were in attendance, curious to see Bill Smothers and anxious to hear Joseph Hamilton Daveiss. The trial itself was likely to be one of surpassing interest and remarkable singularity. Only 2 lawyers would appear, and they were brothers. As soon as the sheriff had made proclamation that the court was open, Smothers tendered himself in discharge of his bond and took a seat within the bar. John Daveiss, the prosecuting attorney for the district, was much interrupted in his duties during the day by repeated questions concerning his brother. "Where is he? When do you think he'll be here? Maybe he will not come at all," and a variety of inquiries and speculations saluted him wherever he went. On Monday night, Joe Daveiss stayed at the house of Stephen Statler, 4 miles from Hartford, and on Tuesday morning he and Statler walked into town. Court was already in session and was devoting the usual hour to motions. Statler and Daveiss sat upon a bench in a remote corner, engaged in conversation. Statler was much the taller man of the two, but they were dressed alike in blue jeans, and to all appearances were a couple of sensible farmers. Statler had no idea that he was talking to Joseph Hamilton Daveiss, but still he was strangely fascinated by his company. When Judge Broadnax had disposed of the motions, he opened the docket and called the case of the Commonwealth versus William Smither, alias Bill Smothers. John Daveiss was upstairs with the grand jury and of course made no response to the call. Statler's companion left him and took a seat by the side of his client, Smothers, who was not in the least surprised at the course of his lawyer, shook him warmly by the hand. Joe Daveiss made no labored effort at cross-examination, but permitted the witness to make their statements in their own way, sometimes putting a single question to elicit an explanation. When the attorney announced that the testimony was closed in behalf of the Commonwealth, Joe Daveiss exchanged a few words with Smothers, and then rose and said that his client, from motions of delicacy, had positively refused to introduce his sister, who was the only witness that could state anything material to the defense, that the prosecuting attorney might proceed with his argument to the jury. But by the feeling manner in which he had made the simple statement, he seemed to already have gained the vantage ground. But John Daveiss was a man of no ordinary ability, and knowing that he had to cope with one of the greatest advocates of this country or the world, he put forth his full strength in his opening speech, endeavoring to forestall the impression which had always attended the powerful efforts of his brother. The evidence was arranged in a masterly manner, and he closed by a spirited and strong appeal to the jury to discharge their sworn duties honestly and faithfully, exhorting them to disregard alike the fame and passion of the orator who is to follow him, and assuring them that whilst the wicked might rejoice at acquittal, all good men would say amen to the condemnation and execution of a marauder, an outlaw, an assassin, and a murderer. That wonderfully eloquent and strangely eccentric man, Joseph Hamilton Daveiss, then rose to address the jury. It was his ambition to do everything after a fashion that nobody else in the world had ever attempted. His manner, his style, his tactics at the bar were all his own, and they all lie buried with their master at the field of Tippecanoe. Now, this is Joseph Hamilton Daveiss would unfortunately die just a few years later, only at the age of 37 in 1811. At the Battle of Tippecanoe. No fragment of a speech of his remains today, and from the erring and fading memories of men we derive our only ideas of the inspiration that moved upon the feelings and swayed the passions until he could drive his triumphal car over any obstacle that might oppose his onward course. Tradition furnishes only a dim outline of his speech in defense of Smothers, which was probably the greatest forensic effort of his life. It was made for a friend without hope of reward, and the whole power of mind, body, and soul were poured forth in his cause. He commenced as if he had a fee to assist in the prosecution. He reiterated the strong points in his brother the attorney's speech, and offered additional arguments in favor of conviction. The friends of the accused began to whisper that he was a snake in the grass, and that he had come to help his brother, and the eyes of Smothers were raised in calm surprise to the face of his counsel. But Daveiss went on, urging that an acquittal, under all the circumstances, would be a monstrous outrage upon the law and justice, and insisting that the jury ought, without hesitation, to hang the criminal. Adopting all the epithets which had been so liberally bestowed, he called upon them to hang the marauder, hang the outlaw, hang the assassin, hang the murderer. Proof or no proof, let the hangman proceed on his mission of strangulation. That such, in effect, was the common reasoning of prosecuting attorneys, and he had been repeating in substance what had fallen from the gentleman who had preceded him, but the law was established upon principles precisely of an opposite character. He dwelt upon the tenderness and mercy of the law, and the safeguard it threw around the life and liberty of the citizen. That malice, premeditated malice, was an essential ingredient in making out a case of murder, and without it there was no murder. That if the killing was in sudden heat, it was manslaughter, and if the blow was given in self-defense or in defense of his family and home, then it became a virtue and was no crime at all. Without a note, he reviewed the evidence from beginning to end, calling the names of the witnesses as he went, and contended that the Commonwealth had failed to prove that his client had slain the deceased, that he was found dead in the house of the prisoner at the bar, but no man had seen the prisoner inflict the wound, that circumstances, however conclusive they might appear, were frequently deceptive. He read a case in the English reports where an innocent man had been exempted under circumstantial evidence even stronger than that before the jury, and took the position that the unscrupulous and vindictive prosecutor was guilty of murder, and that the 12 jurors were his aiders and abettors because they did not require that positive and undeniable proof which leaves no room for a reasonable doubt. That if in truth it was the hand of Smothers that directed the blade, the facts in this case warranted the conclusion that the other was the aggressor, that the prisoner was a man of sense and a man of prudence, and never would have sought an encounter with a giant whose physical force was so great that he had never found an equal, and who had a host of 30 comrades who would have rushed to his call and staked their lives in the quarrel. That the deceased was the aggressor in the beginning, and it was a fair inference that he so continued to the end. That unbidden he had invaded the precincts of the prisoner's home, and in return for civility and hospitality had offered insult and injury. That his foul, false tongue had aimed to fix the seal of infamy upon the spotless tablet of a maiden sister's fame. That when his companions, impelled by repentance and remorse, had left the house, he lingered upon the spot. That if Smothers had slain him, he slew him in the holy cause of religion and of virtue, and that the King of Heaven had strengthened the arm that drove the pointed steel to his heart. He paid an eloquent and glowing tribute to the brave pioneers, who by their toil, sweat, and blood had won the great valley of the Mississippi from the Indians, and consecrated it to agriculture, to commerce, and to the arts. He denounced in terms of bitterest indignation and deep ingratitude of the government, which suffered them to languish and die in poverty and neglect, whilst all his favors and patronage were lavished upon fawning sycophants and cringing parasites and flatterers who knelt and worshipped at the footstool of power. That a golden crown had been tendered to Julius Caesar for his victories in Gaul, and for the addition of that province to the Roman territory. That these men had conquered an empire thrice as great and thrice as fertile as Gaul, and neither the charity nor the bounty nor the justice of the government had ever induced it to bestow on them one as much as an iron skillet. that a representative of that government was here today appealing to a jury of the county for the blood of one of the bravest, because he had stood upon the threshold of his rude hut, which was his castle in the eyes of the law, and had defended his family against the licentious and wanton insults of a blackguard and ruffian. Were he in peace of his client, he would leave his government and seek some boundless contiguity of shade, where the rumor of oppression and of wrong might never reach him more. That if Smothers had to die, it was meet and appropriate that he should die at Hartford. Hartford had been the theater of his valor, and Hartford should be the scene of his execution. That he came with the party that erected the first fortification, that his hand dug the ditch and planted the palisade, and when the Indians besieged and fired upon you from stump, bush, and tree, whose aim was deadliest, and whose rifle rang clearest in your defense, and when they were defeated and turned their backs in retreat, who was fleet-footed enough to lead the van in the pursuits, who hovered around them like a destroying spirit until he had dyed the waters of your rivers in their blood, who trailed them to their homes beyond the prairies and restored your stolen property without ever receiving 1 cent in compensation, that whatever falsehoods may have been invented and circulated against his client, the forked tongue of slander itself had never charged that his soul had been stained by the sin of avarice. That with ample opportunities of securing an immense landed estate, there was not a foot upon the earth that he could call his own, that while others had enriched themselves by speculation, peculation, violence, and fraud, the poverty of Smothers was a vindication of the sterling integrity of the man, that his public service needed no rehearsal, that Isaac Shelby in a conversation had endorsed the heroic conduct of the boy Bill Smothers at King's Mountain, that he carried in his pocket an honorable discharge from General Greene after the great battle of Entau, that after he came to the West, the hills and valleys and rivers had witnessed activity that never tired, eyes that never slept, and courage that never flinched in the hour of danger, that if they met the demands of the government official by the sacrifice of the life of the prisoner, let the martyrdom occur on the mound on which we stand. Let the last glances of the departing soldier rest upon the scene where in the vigor of his manhood he drove to give peace and security to your homes and firesides. And as his slender form swings in the air, take a long and last look at the truest and boldest man that ever raised an arm in your defense. In his charge to the jury, Judge Broadnax himself approved the able lawyer and the upright man. Forgetting the many annoyances of Smothers, he exhorted the jury to look in mercy upon the prisoner and give him the benefit of every reasonable doubt. The jury, after a retirement of 10 minutes, brought in a verdict of not guilty. So that's the end of what I'm going to read for this episode. So this story was from this book, History of Daveiss County, Kentucky. And so Daveiss County was, of course, named after Joseph Hamilton Daveiss after his death at Tippecanoe. So next time along this line of about Bill Smothers, I'll talk about what he did after he was acquitted of murder. He decided to take Joseph Hamilton Davis's advice and sort of just leave Kentucky and wander around out west, basically, for many years. So if you want to see more episodes like this, then be sure to like and subscribe, and we'll see you next time on Unworthy History.